Hi, warriors. This is Jalen, my legal warrior, and today we have a special guest.
Hi, everybody. My name is Stefano Molea. I'm a criminal defense attorney here in San Diego. I'm a partner at the law office of David Shapiro, and we help good people regain control of the future when charged with a crime, which means that we represent individuals charged with anything from a DUI all the way up to murder and everything in between.
Gotcha. Well, thank you so much for joining us. We're really looking forward to receive some top-notch information from you. My first question I'm going to start off with is, what abusive behaviors lead to an arrest during a quarantine?
So what we've seen as far as charges during this time obviously relate to domestic violence, with people being in confined quarters for long periods of time. Obviously, sometimes anxiety is high and tensions are high, and unfortunately, that sometimes turns into physical violence. So typically, what happens is individuals will be arrested and charged with a number of domestic violence type of cases, and that could include things such as domestic battery, which is outlined under PC Penal Code Section 243, subsection E1, and that's simply using harmful or offensive touching towards another person that you have a domestic relationship with. Then the level above a 243E1 or domestic battery is corporal injury to someone with a domestic relationship, and that's defined under Penal Code Section 273.5. And the difference there is that with the PC 273.5, there's a traumatic condition that results as from the harmful touching. So that can obviously be a scratch, that could be sometimes obviously a bruise, anything of that sort, redness. If you have any redness, especially around the neck or face, or really anywhere else where there's a mark that can be seen, typically that will result in a felony arrest for PC 273.5. But that sort of doesn't completely define the domestic violence types of charges that we see during this time. There can be domestic violence vandalism. So I know that that seems weird. How can vandalism, how can breaking a piece of property or damaging property potentially result in a domestic violence arrest? Well, if it's done within a domestic setting, and there's property or something that's damaged, or like a TV, for example, or a phone is broken, or anything of that sort. If it's $400 or below, it's a misdemeanor. If it's above 400, it's actually a felony. And so that's a common arrest during these times. And then finally, there's a Penal Code Section 591.5, which is trying to interfere with someone calling for help. So let's say that there's an argument of some sort and one person feels like they need to call police or some kind of assistance from first responders, something like that. And that person then decides, the other person decides to try to grab the phone and prevent them from calling, then there could be a misdemeanor charge under that code section as well.
Wow. So you've seen a lot of those calls come through.
What's happening right now is that for most cases, individuals are being cited and given a court date in the future. Because there's been a big move to reduce the population in jails. They're not booking people into custody, except for violent crimes, domestic violence crimes, crimes against children, obviously. Those things still will result in arrest and being booked and having bail set. But for most other cases, people are just going to get cited and released with the future court date. So definitely, even for misdemeanor domestic violence, individuals are being arrested and having to bail out.
Okay, so that leads us into the second question. If somebody is in fact arrested for alleged domestic violence, are they offered bail? And it sounds like the answer is yes, they are offered bail.
Right. DV cases, definitely a category of cases where people are still getting arrested, as I mentioned. And what's interesting is there was actually an emergency bail order that came down from the California Supreme Court that change the bail schedule. So typically when somebody gets arrested, no matter what kind of charge it is, that person will be arrested, taken down to the appropriate jail, and then booked in. Based on the charge that they're being arrested for, law enforcement will refer to a countywide bail schedule, where essentially there's a list of the alleged crime, and then there's a bail schedule next to it that tells us what the bail should be set at, okay? And for most crimes now, where people get arrested, that bail has been brought down to 0. So
Wow.
even for people who were in custody before the pandemic hit, who had a high bail, their bail got reduced to 0 and they were being released. Now, there is a specific category of charges that still have the standard bail, and obviously serious and violent felonies, Penal Code Section 69, which is essentially battery on a police officer causing injury, violation of a court order, that's something that will still require bail. Dissuading a witness is one of them, and of course the domestic violence charges, specifically the 243E1, which is domestic battery, and then the 273.5, which is corporal injury. Those two will still require bail to be set. And I've seen a number of people get arrested and booked into custody, and then requiring bail to be posted.
So how long are they in jail for after the arrest?
So usually it takes somewhere between 4, 6, sometimes 8 hours from the time of the arrest for them to be processed through the jail and for them to be bail eligible, or where they can essentially bail the person out. Then from there, it takes, potentially 4 to 5 hours to get them out once bail is posted. So, if someone gets arrested, it could be 10 to 12 hours typically before they can get out if bail is posted. So once they are booked in and processed, the protocol is the family will call, with the assistance of an attorney or by themselves based on their own research, will call bail bondsman or bail bonds company, and then that entity will essentially post the entirety of the bail for a fee. So let's say that the bail is $10,000, for instance, on a domestic battery under 243E1. If the bail is $10,000 and they don't, and they contact the bail bondsman, that bail bondsman will post $10,000, and their fee will be anywhere between typically 8 to 10%. So potentially someone could be paying a bail bondsman $1,000 so that bail bonds company will post the full $10,000 for them. That's one option. The other option is, if they have the funds liquid, they can actually cut a check and pay the entire $10,000. Then there's no sort of middleman fee. And that allows them to bail out. And then once the case is done, whether it's filed and there's a resolution of the case, or whether there's a determination that no charges are going to be filed, then that bond will be exonerated, meaning that whoever posted the bond will get their $10,000 back. However, if the person who's arrested or the family who posted bail through a bail bonds company obviously pays that premium, that $1,000, for example, they will not get their $1,000 back, right? That's just the premium you pay in order to have the bail bonds company accept the liability and put up the money.
Interesting. I actually thought that the answer would be that they're expediting all of this, and so they're actually having less people stay in jail given COVID-19, but it sounds like your answer is the exact opposite. They're still processing it in due course, and whatever happens, happens. So if they end up catching COVID-19.
Right. And look, and they have done, I think, a decent job, and there's certainly some issues, I think, as far as, I think, some debate about categories of cases should remain in custody, setting bail at 0. But domestic violence and those two code sections that I've been discussing specifically are included in the exception to the no bail, or to the 0 bail, I should say. So definitely on DV cases, people are still getting arrested. What's sort of the other part of your question, though, was, okay, well, let's say that they don't post bail. Let's say they can't post bail. What happens then? Now, before the pandemic hit, you would be required to be brought in front of a judge for arraignment and for your bail to be addressed within essentially 72 business hours. Okay. That by emergency order now, that 72 hours has been extended to 7 days.
Wow.
Now, so someone can be in custody weeks now before they're able to go in front of a judge and make an argument about bail potentially being reduced or there being certain conditions set and that sort of thing. So there's still some uncertainty, and there are some lawsuits that have been filed with regards to individuals staying in custody for a long period of time waiting to see a judge. For instance, I have a situation where a gentleman was booked into custody on April 17, and his court date is May 1st. And so there are certainly some issues there. But, you know, the courts have been working to establish some normalcy and to triage the most important cases. And so they've as of about a week and a half ago, they've started holding video conference hearings on the criminal side to address those high need cases and those time sensitive cases, such as people in custody, and then issues related to maybe an argument that someone who would ordinarily fall under the emergency bail order that would essentially require them to be released. Sometimes a prosecuting agency may have a problem with that, and so they may file an objection, and that essentially triggers a hearing. But there's also a lawsuit related to that regarding how the court is handling those as compared to the specific order being made by the Supreme Court. So definitely uncharted territory, but everyone's working through it.
Yeah, interesting. Well, are CPOs still being issued during COVID-19?
Criminal protective orders are still being issued if someone gets arraigned. So typically criminal protective orders are issued at the time of the arraignment, and an arraignment is essentially a time where the prosecuting agency files the charging document, which is typically a complaint that lists the specific charges and the allegations. And that is the first step in the criminal justice process. So in that scenario, the defendant will appear in court with their lawyer and enter a not guilty plea. 99.99% of the time, we always plead not guilty at the arraignment. And that's when the prosecuting agency will almost always request a criminal protective order. And that, of course, would require the defendant not to have any contact with the complaining witness or the alleged victim, not to come within a certain yardage, not to have any communication whatsoever, either direct or indirect. Now, there's also another potential sort of watered down criminal protective order, and that's called a no negative contact order, in which there's still an order being made by the court of protection, but it simply says you can't have any negative contact with the complaining witness, with the protected party. So you can't harass, strike, annoy, that sort of thing. So that's what normally happens. That's when criminal protective orders are usually issued by the court and then obviously served personally on the defendant. However, because out of custody arraignments are being postponed into June and July at this point, criminal protective orders are not being issued. Now, they can be issued if there is a in custody arraignment where it's done by video conference. One of the orders that was issued by the California Supreme Court creates some flexibility in terms of what used to be the requirement that the defendant be personally served with a protective order. And now essentially the emergency order says, well, if they're present and they accept it and they're there, then that is sufficient for someone to potentially prosecute a defendant if that defendant were to violate the criminal protective order later down the road. So, but most domestic violence cases are resulting in individuals bailing out. At least that's been my experience. And so because of that, the criminal protective orders are not in play. However, an alleged victim or complaining witness, I mean, those are interchangeable terms, but can always ask for an emergency protective order, which gives them a short sort of window in which to get protection, and allow them to potentially file a restraining order, right, a TRO. And so that's still available to an alleged victim.
Interesting. So the process is just a little bit different for an out of custody defendant versus somebody that is in custody.
Yes.
Okay. Well, are there any delays right now in the court system for defendants getting arrested due to alleged abusive behaviors?
No, no. So when it comes to domestic violence, individuals are still being arrested. They're still being booked. Unlike, for example, drug possession or um, some other non-violent types of alleged conduct, um, individuals who are um, found to, at least by probable cause standard, violated a domestic violence penal code section will still be arrested and will still be booked. The delay, unfortunately, will happen if the individual is booked into custody and they can't make bail.
Right.
Then they're going to be in custody a lot longer than they would have been if it wasn't for the pandemic.
Okay. All right. Well, what tips would you provide to someone if they did, in fact, get arrested for alleged abuse against someone?
Well, look, I mean, the criminal defense golden rule is to remain silent. Any statement that anybody makes to law enforcement or to anyone other than an attorney or someone with a privilege can be used against them. And, and that can be difficult to do sometimes, especially in domestic violence setting. But sometimes sort of the arrest that will follow, someone's going to get arrested if there's a domestic violence call. Okay, that's almost virtually guaranteed, right? And so sometimes someone's thinking, okay, well, if I tell them what happened, then maybe I won't get arrested. Certainly that's a possibility. However, if you make a statement, not understanding that your statement is an admission of violating the law, or if there's a credibility issue between you and the other person, a lot of times when you make a statement, you don't have the luxury of being able to specifically respond to what the other person's allegation is. So it's never a good idea to make a statement when you're in information deficit, because you may say something that's true, but then the way it sort of compares and contrasts to what the other person's saying, which the other person may be found to be more credible, may actually corroborate their story and then definitely support your arrest and criminal charges down the road. So that's one thing to keep in mind. But I understand that's difficult to do. With that in mind, I think it's probably worth addressing one of the most frequently asked questions I get, and a huge misconception out there, which is, they didn't read me my Miranda rights. So what does that mean? Does that mean that everything can go away? So first and foremost, the rule is that your Miranda rights and your right to remain silent and to an attorney don't have to be read to you unless there's a custodial interrogation. And what that means is that you actually have to be under arrest, and then the law enforcement officer has to be asking you questions designed to elicit an incriminating response. In other words, they are asking you questions to try to get you to talk about what they arrested you for. So when you first have contact with law enforcement, you're not under arrest. You may be detained, but you're not under arrest. So they have no legal obligation to read your Miranda rights. And so everything you say is going to be used against you during that time period. And that even applies in situations like traffic stops, right? Even on DUIs, for example. You get pulled over, they ask you where have you been, where are you coming from? You're detained, but you're not arrested. And so all those questions, all those statements you make will definitely be used against you. They don't have to read your Miranda rights. So that's a big one. And then, ultimately it's important to understand the bigger picture when it comes to criminal investigation and criminal justice system, is that the accused has no burden whatsoever. So the prosecution has the burden of proving each and every element of the crime beyond a reasonable doubt. So keeping that in mind and making sure that the defendant or the potential defendant doesn't do something to aid in his or own prosecution is critical. it can be difficult, right? You know, not everybody has the ability to sort of get a primer on civil rights and your right as a citizen. And a lot of times people get information from TV shows and that sort of thing. And they're thinking, well, as long as they haven't read me my Miranda rights, then I can talk and none of this can come in. Well, that's not how it works, right? So remaining silent is definitely important. And then if you are arrested for a domestic violence type of case or any case, and you're given, for example, a court date that's a month or two out, some people might be thinking, well, I'm going to wait for my court date. That is also a big misconception, because there is a lot of work that can be done, a lot of productive work that can be done between the time that you're arrested and the time that you have your arraignment. And that work involves hopefully finding an attorney that is a good fit for you, that you can afford, that has the experience and the reputation to do good work for you. And once you find that person, that attorney can reach out to law enforcement agency, can reach out to the prosecuting agency, and work towards providing a different perspective that comes from the attorney. It can also work towards providing additional evidence that maybe wasn't available originally, that can help essentially demonstrate to the arresting agency or the prosecuting agency that this is not a case that they'd be able to prove beyond a reasonable doubt, or that it's not a case that they should take on for any other reason. And fortunately, we've been, you know, lucky to be successful in doing that work. And even though somebody gets arrested, because of some of the legal work that gets done in between the arrest and the court date, that the prosecuting agency decides not to file charges at all. And so some people like to kind of roll the dice and just kind of wait and see. That is certainly not a safe approach and not a smart approach when you have so much at stake, as far as your time, your reputation, and of course, you know, your freedom. So that would be another big tip: is don't think that the time between your arrest and your court date is time to be wasted. It can be used very productively if you bring somebody on to your team that knows what they're doing.
Okay. Yeah, that's actually a really great tip. I am wondering whether if you were able to convince the prosecutor that this is not worth your time, given the new evidence or corroborating evidence, that they'll actually dismiss the upcoming court date, or it will remain on calendar and the defendant wouldn't have to appear and the prosecutor dismisses it then.
Great question. Great question. Yes. So what happens is when someone gets arrested and they bail out, and we're obviously functioning under this assumption that the person's able to bail out. Right. When they bail out, they get this bail receipt, and it has their charges and it has the future court date. So right, you would think, okay, I have to go to that court date regardless. Now, if you don't have an attorney that kind of helps you with this pre-file work, right? So your charges haven't been officially filed yet, and the attorney's trying to do what is possible to prevent charges from being filed, or at least influence the way that the case is perceived, right? So in that scenario, if the attorney gets word from the prosecuting agency that they've declined to prosecute, they've rejected the case, then there's going to be no need to go to court. There won't be a complaint filed. There will be nothing on calendar. There will be no need for the defendant to go. Sometimes what can happen is that the attorney would be able to actually get a letter from the prosecuting agency stating, hey, we reviewed the case and we've decided not to file charges. To tell you a little bit about what that letter looks like, first, that letter can't be obtained until after the original court date, right? So the court date that was originally contemplated, we have to wait until then in order to be able to get it. But once that court date comes, then we'll be eligible to go there and make the request. And then you get that letter. And what that letter will say is, we reviewed the case, and the case is not something that we want to pursue, right? We've decided not to file charges. However, please remember that if we receive additional information, we can still file within the statute of limitations. And that could be on certain DV cases up to 4 years now, as of late, in terms of a change in the statute of limitations. So that is a significant amount of time in which, if they receive more information, they could theoretically file. Now that is not common. It's not common that someone gets arrested, they review the case, they reject it, and then later on they decide to file. That's really the exception. But normally that would happen if, let's say, they think it's a close call, but they decide not to file charges, and then there's another incident involving the same defendant. Then they're thinking, okay, now this is evidence of a bigger issue here, and then sometimes they will file on the new case plus the old case. So we do see that sometimes.
Okay. I do have one more question, because you touched on violations of the restraining order, and if somebody does violate it, they will in fact be arrested. And I have so many of my clients that tell me that they reported it to law enforcement and the police just doesn't do anything about it. And it could be a minor violation, like they texted them asking about the kid, even though there is no brief and peaceful contact. That's part of the domestic violence restraining order. And even if they report it, law enforcement doesn't do anything. And that's just been the assumption, that you still report it, but don't expect that law enforcement will actually take them in. And on my part, we could file a contempt action, sure, but I think the main thing that the client wants is for law enforcement to actually follow the restraining order, especially since it says on there that this can result in your arrest. And when law enforcement doesn't do it, they're left puzzled. Like, what's the point of having this piece of paper? Even if the slightest contact, they're not getting punished for it.
Yes, definitely. And what's tough in that scenario is that it's so dependent on the discretion of the law enforcement agent who receives the report. It's so dependent on individual agency policy as far as how they handle those types of situations. I've definitely seen scenarios where there is a defendant who violates the restraining order, and law enforcement will call them and say, hey, this is a violation of a restraining order. If you do it again, we're going to come and get you. So sometimes there is sort of we're going to give them a chance type of situation. But it is obviously discretionary for the officer. Ultimately, however, filing the report is still important because it starts the process, it documents everything. And so that's certainly significant. And then, of course, once there is the actual, again, assuming this is a temporary restraining order, once there's the actual trial on potentially imposing a permanent restraining order, then evidence of a violation of the temporary order is certainly going to be helpful. And documenting that is going to be very helpful if the protected party is seeking to get a permanent restraining order. So having the report numbers and everything else about the violations, even if they're minor, is important. So, and one thing, Jalen, that we were talking about earlier that I want to make sure that I address because it's super important is when you were asking earlier about the date on the bail receipt and the date that's supposed to be the arraignment. One thing that's important is that because the prosecution has the ability to file charges within the statute of limitations, sometimes the date on the bail receipt that's supposed to be your court date, your arraignment date, will come and go, and the prosecuting agency doesn't even get the reports, so they don't have anything to review. So sometimes, let's say that I have an arraignment on June 1st, and I check in with the DA's office or the city attorney's office if it's a misdemeanor downtown. And I keep checking to figure out what's going on, where the case is. And they tell me, we don't have reports, you don't have reports. We've never received anything. So sometimes there's the disconnect between law enforcement giving the reports to the prosecuting agency. And even if sort of the transition of giving the reports to the prosecuting agency happens after the arraignment date that's scheduled, that means that they can still file past the date that's on their bail receipt. And that's an important factor to keep in mind, is sometimes when you go to the prosecuting agency, they'll say, we just didn't receive any reports. But when we do, then we're going to review it. And sometimes that results in someone getting a notified letter. So they'll get a letter in the mail saying, hey, we got the case, we reviewed it, we've decided to charge you. Here are your charges. Here's your new court date for your arraignment. Other times, unfortunately, they will issue an arrest warrant and then go and arrest the individual. and what's unfortunate about that is it's like, hey, I showed up at the court date, nothing got filed, you guys didn't get the reports, I went on living my life, and then all of a sudden they get arrested because the reports came in late and they decided to file later. So that's another piece of information that I think is important for your viewers.
Interesting. First question that comes to mind is, how is that constitutional? Or is that notice and opportunity heard? At that point, you're just getting arrested and that's it. And your hearing date just passed.
Right. It is very frustrating. And the law, again, the law just unfortunately allows the prosecution to file with statute of limitations. And I've seen situations where someone gets booked on $100,000 bail, for instance, and they pay close to $10,000 of their money to bail out.
Right.
And their court date, their original court date, comes and goes. And then all of a sudden, the prosecuting agency decides, well, we're going to, despite the fact that we know this person bailed out and showed up to court, but nothing was there because we had made a decision, we think this person's a danger to the community, we have to issue an arrest warrant. And then they issue an arrest warrant and the person gets picked up, and sometimes they're back in on another 100,000. And guess what? That's another 10 grand potentially.
Mm-hmm.
So that's another potential benefit of having someone in your corner
Yes.
before the court date, because then I've worked it out with prosecutors where I say, hey, don't go and arrest them on this bail. Let me sort of figure everything out. Let's try to set up something that makes everybody happy so that this person doesn't have to be booked in again. And so there are definitely steps that can be taken proactively in that scenario as well.
Yeah, it sounds like a very good solution. It sounds like you know the ins and outs, and it sounds like, I want to say connections, but you have at least a reputation with the law enforcement agencies and the prosecutors, so you'd be able to negotiate that. So that's very great to know. Well, thank you so much again for taking the time to be with us and assisting our viewership about the different things that they can in fact do during, COVID-19 if they did in fact get arrested. The thing that bothers me, the most is that they're just allegations and they have to go through the process and that, like you said, it can be 7 days plus. And that's just the unfortunate thing. And if they don't get a CPO, they could get a DVRO based off of just those allegations, and then it's extended a little bit more. So this
Right.
was great. This was really great.
Thank you so much for having me. I really enjoyed it. And if there's anything I can ever do, reach out.
Yeah, why don't you go ahead and please give us your phone number and how our viewers can in fact get a hold of you.
Definitely. Our phone number is 619-295-3555. Our office is located in the Hillcrest area in San Diego. However, we handle matters all over San Diego County. And then obviously online, davidpshapirolaw.com. And you can find me on LinkedIn. I'm on Instagram under the handle San Diego Criminal Defense. And I'm also on Twitter under Molea Law, MOLEA-LAW.
Okay, fantastic. Thank you so much again, and enjoy the rest of your afternoon.
Great. Thanks, you too.